Hello, my name is Jeffrey Cunningham. I'm an associate at Goldberg Segalla LLP. Today we'll be discussing an introduction to legal malpractice claims and related ethical issues. Overall, today we're going to be talking about these two major sources of risk to attorneys and how they overlap. And at that overlap is the most dangerous period in an attorney's practice. That's where most of the claims come from. Today, I like to keep in mind what I think of as the dartboard with the attorney at the bullseye. You know, if you think about a dartboard, there's multiple colors, right? The standard dartboard has black and white spaces for the larger target, and then there's the smaller double and triple scores, even if you're not that familiar with dartboards. Just trust me on this. There's double and triple scores, which are typically red and green, and those are smaller areas. And that's sort of where the overlap is. And what I really like about the bullseye dartboard analogy is that the attorney is at the target. The attorney is the bullseye, and that's important to keep in mind. We'll discuss a little later on what makes attorneys particularly vulnerable, but also particularly valuable targets to legal malpractice claims and dissatisfied clients. Just a brief course overview. We're going to talk about, obviously, ethics and malpractice, an introduction to just the standard nuts and bolts of a legal malpractice claim. We're going to look at a 50-state survey, essentially. And I'm not going to hit on every state, but we'll talk about nuances from each state and examples from each state. And throughout the presentation, we'll use actual cases to sort of dive into the various aspects of a legal malpractice claim and the related ethical issues. And today we're going to be using the ABA model rules typically to discuss the various ethical obligations and how they interact with legal malpractice claims. Obviously, each state's rules are going to be a little different, but most states have adopted at least the major model rules we'll be discussing today anyway. And just generally speaking, ethics versus legal malpractice. Ethics involves professional ideals, sort of an academic approach, while malpractice claims really tend to cut towards the common practice, what an attorney in your jurisdiction, in your city, in your practice area does. Ethics generally involve intent, and malpractice generally involves negligence, almost always involves negligence. But so there's a split there in the motivation behind the attorney. Now, you could certainly have a negligent ethical violation as well, but typically there's some aspect of intent or more than negligence involved. Ethics violations generally are conduct-based, so a course of conduct over time. An attorney fails to do this or that for an extensive period. That's not to say one instance couldn't prove to be a terrible ethics violation, but typically it's a course of conduct, whereas malpractice is sort of the other way. Malpractice generally involves one mistake, one instance where the attorney fails to adhere to the standard of care and causes damage. Ethics complaints are handled by the state bar associations typically, whereas malpractice claims are dealt with in state court, federal court, but primarily in state court. Jumping right in, I like to start with the duty to disclose malpractice and what sort of obligations the attorney owes the client when malpractice occurs or when malpractice may occur. According to the model rules, which is contrary to most jurisdictions, the attorney does owe a duty to disclose potential malpractice to a client. ABA Model Rule 1.4 provides for client communication. 1.7, the personal interests of the lawyer and how it cannot impact the representation of the client. And ABA Opinion 481 dives into Rule 1.4 and requires the attorney to inform the client if the lawyer believes an error is, quote, material. Now, whether the error is material, that there's plenty of room for discussion there. But the thrust of the ABA's opinion is that if the mistake or the issue, the act, omission could arise to malpractice, that would be material. That could cause damage to the client. That's something that ethically the attorney is required to disclose. The Restatement of Third Governing Lawyers, Section 20, again puts the obligation on the attorney, and a minority of jurisdictions find there is a common law duty to disclose malpractice, such as in Texas. There's also a risk for not disclosing malpractice, where you may not be committing an ethical violation per se, you may not be committing malpractice, but you could expose yourself, the attorney could expose himself to a breach of fiduciary duty type claim. And this is seen in Pennsylvania and a series of other jurisdictions where it's an issue of first impression, where there isn't an obligation on the attorney to disclose malpractice, but it rises to some other claim, so some sort of breach. There's also, in the duty to disclose, cutting the other way, serious, significant malpractice insurance considerations. So before any sort of disclosure is made, you should certainly contact a competent attorney who can help you guide you through the ethical issues, the legal malpractice issues. But you also want to be in touch with your malpractice carrier because you don't want to jeopardize the potential insurance because you jumped the gun on disclosure.